Now to the legal landscape, our legal analyst, attorney Dan Adams, joins us every Monday, breaking down the biggest cases happening across Wisconsin and the country. Good morning to you, Dan. Good to see you. Let's start with the Wisconsin Supreme Court. They're taking up the case of the Wisconsin Elections Commission versus State Senate Majority Leader Devin LeMahieu. Break down what this case is all about and what the state Supreme Court will ultimately decide.
Hey, good morning, buddy. So this is an unusual controversy. This is about who gets to run the State Elections Commission. The commission was set up 3 years ago so that Democrats and Republicans both had 3 votes on that commission. Now, they've been at cross purposes, unable to vote in a majority. And so there's 3 votes on each side, and they can't agree on whether or not to reappoint the administrator, Megan Wolf. And so since they can't make a decision here on whether or not to reappoint Megan Wolf, she has essentially retained her job as what's called a holdover. And she's been a holdover in that position for 1.5 years, just about. So the case is in front of the Supreme Court today for oral argument as to whether or not state law allows this indefinite holdover position, or whether or not the administrator position must be refiled and go through state Senate confirmation process. So it's a really kind of esoteric case that we have here about state law. And it's made worse because this election commission itself is only an entity that's about 8 or 9 years old. So figuring out what to do here when the commission can't come to a decision is what the Supreme Court's deciding.
Yeah, and the commission's chair telling us just yesterday and up front that she hopes that Wolf decides to stay with the commission and that the court allows her to do that. So much more to come from these arguments, which pick up this morning. Let's talk about this past week, the murder trial that started for the man accused of killing Georgia student Laken Riley. This is a case that really ignited a national immigration debate during the presidential campaign. Right before the trial started, though, last week, the defendant, Jose Ibarra, waived his right to a jury trial. What is that, and why would a defendant make that decision?
Right. Well, you kind of put your finger on it. The national wave of attention, the emotions regarding the issue of an undocumented person accused of killing a college jogger is what's making the defense here decide to waive jury. Waiving a jury almost never happens. A jury is a great thing. It's the best tool that's ever been invented to fight government overreach. So why would you waive it? Well, first and foremost, you just believe that the jury would not be the best group of people to weigh evidence in the case. And that, again, that almost never happens unless something is so emotional in the community that you believe that taking that outrage and the emotion out of the equation and giving it to a more dispassionate person, that would be a judge, to weigh the facts and place the state to its burden of beyond a reasonable doubt would be advantageous to the client. This would be a case where maybe the evidence is weak, but the emotional impact of the case is very strong. And so that's what I expected the defense was thinking about when they decided to waive jury in the matter.
Dan Adams, always great to have your insight and analysis. We'll see you next Monday for more of The Legal Landscape.